All right, everyone. Good afternoon. This is Len Suzio with Your Data Vision. We're going to be talking today in the next hour about the new CRA, which, to everyone's pleasant surprise, I guess, was postponed from having an applicable date starting April 1st. It, by the way, still has an effective date of April 1st, but the provisions that were applicable to April 1st were only a few in number, and those applicable sections, which had an effective date of April 1st, 2024, have been postponed to 2026. Nevertheless, uh, Connecticut banks in particular had a have some concerns with the new regional planning regions, which have big implications for CRA. So we're going to talk about that as well. And we will talk about some of the changes that will have been in effect on April 1st of this year, but because there's a lot of confusion about what the public file requirements are, for example. So we'll talk about that as well. Let's see. uh, so let me move on. So let's go forth. So we're going to talk about the effective and applicable dates, the new planning regions, which are going to be a big topic, and the new MSAs, and their effect on assessment areas for Connecticut banks, what the restrictions will be on facility-based assessment areas when they do become effective on January 1st of 2026. What will the new CRA bank size categories be, what they are today and what they will be under the new rule. And of course, we'll talk about the public file requirements as well. What did I do here? All right. So I'm going to talk just very briefly about the new facility-based assessment areas because they're not going to be effective next week as was anticipated. But nevertheless, uh, you should be aware of what their implications will be when they do go into effect, because there should be some planning involved in this for each bank. So therefore, it's important for you to be aware of what the implications are. So regarding the new facility-based assessment areas, they are in some ways very similar to the current assessment area configurations. They have to contain deposit-taking facilities, but for large banks, they're going to lose their flexibility in terms of taking parts of counties. They're going to have to incorporate entire counties, or in the case of Connecticut, county equivalents, which would be the planning regions, which are replacing the counties, and which we're going to talk about quite extensively today. And they will not be able to cross against a state boundary unless they're in a multi-state MSA, and they cannot cross an MSA boundary at all. For small and intermediate banks, they'll continue to have the assessment area flexibility that they have today, so they can annex parts of counties, or again, in Connecticut's case, planning regions, to reflect the area they can reasonably be expected to serve. So just briefly, small banks today under the current rule, which will now remain in effect, are $391 million, less than $391 million. Intermediate small banks are going to be 391 million up to, but less than 1.564 billion for the last two calendar year ends, and large banks will be 1.564 billion or above. And it's been quite a bit of confusion regarding bank size, which has been created by the regulators and their intention of making the new facility-based assessment areas effective on April 1st of this year, but delaying the definition section of the new regulation, which would have meant that that the bank size intervals would have been postponed until January 1st of 2026. And any bank that is over 1.564 billion now would be considered to be a large bank, but under the new rule, when it becomes effective, would have been an intermediate bank. And that's a very critical distinction, because intermediate banks and small banks, like I said a few minutes ago, retain their flexibility as far as annexing parts of counties, whereas a large bank would not have that flexibility. And there's several of you who are participating in today's meeting that fall in that twilight zone, between the $1.564 billion size category and the $2 billion size category. And you were caught in this awful situation in which you were going to be deemed to be a large bank under the new rule, had it gone into, well, had the applicability date happen for February for facility-based assessment areas next week on April 1st. And therefore, and in 2 years later, on January of 2026, you would have been able to fall back into the intermediate bank size category, which means you would have temporarily lost your flexibility to delineate an assessment area less than a full county or again, a planning region in Connecticut. And you would have regained that ability in January. It made no sense at all. And I think finally the regulators recognize that. And that's one reason why they pulled back and decided to change the applicable date for the facility-based assessment areas to coincide with the change in bank size definitions as well. So everything starting April 1st next week remains in effect as far as CRA is concerned. However, the planning regions are coming into effect, are already in effect in Connecticut, and that's caused for a lot of confusion. So we're going to go through a bunch of slides today which depict the new regional planning regions and lays over them the county boundaries as well, because unfortunately they just didn't make the new planning regions coincide with county boundaries. They overlap into multiple counties, and this is going to cause big problems from a CRA point of view. So the map that's on your screen right now is color coded, okay, and the color coding are the counties, and the dash boundaries represent the new planning regions. So you can see Litchfield County and Fairfield County, Naugut, and New Haven County, as well as Hartford and Middlesex, etc. The 8 counties that exist in Connecticut today, they're labeled there and they're denoted by the color coding. But now you see the dashed lines, the bright blue dashed lines, and those are the new regional planning regions. And you can see that every county in Connecticut has been affected by that, and some counties more dramatically than others. So Fairfield County probably has been affected the most among the 8 Connecticut counties. And by the way, I didn't say this, but if you want to ask questions, definitely post them, and I'll take a look at them at the end. And since there's a small group today, we're talking. We anticipated about 20 people. We can actually have a discussion. It won't be like 300 people trying to talk all at once. I might just ask that you might raise your hand or something so I can call on you to ask your questions when we're toward the end of my presentation. Okay. So again, this map shows you the existing counties denoted by the color code and the overlapping of the planning regions denoted by the dashed blue lines. And as I was saying a minute ago, Fairfield County gets affected the most because it gets broken technically into 2 planning regions. There's the Western Connecticut planning region, and then there's the Greater Bridgeport planning region. And also infringing on it just a little bit is the is going to be the Naugatuck Valley planning region as well. You can see pointing down into the Greater Bridgeport area is a little part of the Naugatuck Valley planning region. So you're going to see, in effect, 3 planning regions replacing Fairfield County. And on top of that, if you look up in the northern part of the Western Connecticut regional planning region, you can see that the Western Connecticut planning region infringes or basically overlaps into what's called Litchfield County today. So technically, you're talking about 3 different counties and 4 different planning regions in that little section of Connecticut that's in the southwestern part of Connecticut. And then when you look at New Haven County itself, it gets broken up into 2 planning regions. You got the Naugatuck Valley planning region and the South Central Connecticut planning region. In the meantime, Hartford County itself, which is denoted in blue, becomes the capital region, with some of that infringing on what has been Litchfield County. So each bank that's participating today, you're all from different parts of Connecticut. This map gives you a good, excuse me, indication of this interplay between the counties and the planning regions. And this is another kind of look at it. Now, this is a little more clear as far as the planning regions are concerned, because now I'm just showing you, I'm not overlapping with the counties. We're looking just at the planning regions themselves. And you can see the 9 planning regions. You've got Western Connecticut in this southwestern part of the state, in the greater Bridgeport planning region. You've got Naugatuck Valley, Northwest Hills, which is most but not all of Litchfield County. It actually incorporates parts of Hartford County. And then you've got the South Central Connecticut planning region, which is denoted, it's around the New Haven area. And then you've got the capital planning region, which is Hartford, most of Hartford County, but not all of Hartford County. And it's most of Towland County, but not all of Towland County. And then finally, you have the northeastern Connecticut planning region, which is almost all of Windham County, but part of that and fringes down into what's New London County. And last but not least is southeastern Connecticut, which is most of what has been New London County. But again, not quite all. Part of New London County is now into the lower Connecticut River Valley planning region. So it does create a lot of confusion because every single county is now part of one or two planning regions. In fact, I think every single county is part of at least 2 planning regions. And some of the planning regions include combinations of 2 or 3 counties. Going to make it fun to figure out what your assessment area is. So let's take a look at each one. So this is the Western Connecticut and the greater Bridgeport planning regions. You could see again denoted by the boundaries that are the dashed blue lines. And you could see how Western Connecticut infringes on what had been part of Litchfield County. It still is. The counties, by the way, still exist. It's not like they do not exist. It's just that we're talking about this is something the Connecticut legislature, in its wisdom, decided there was some advantage to creating these new planning regions. And as you would expect, it's usually got to do with money from the federal government. Now, this is what is Litchfield County, but you can see it's called the Northwest Hills Planning Region right now. And those blue colored tracks up there on the eastern side of that planning region are Hartford County tracks, basically. And they still remain Hartford County tracks. But for these purposes, it's those 2 tracks are now part of the Northwest Hills Planning Region, which is almost all of Litchfield County, but not quite. Now, we've got the Naugatuck Valley and the Central Connecticut planning regions. So they include parts of 4 different counties. Excuse me. So you can see the Naugatuck Valley region includes part of what have been Litchfield County, a one track, Bristol, which has got a number of tracks which have been part of Hartford County, basically. You can see that's the blue colored area up there. And then you've got South Central Connecticut, which is part of New Haven County. And then you've got that little niche down there in the lower southwestern corner, that tan colored area, which is part of the Naugatuck Valley area, but which has been part of and continues to be part of Fairfield County. So that tan colored area is the Fairfield County section of the Naugatuck Valley planning region now. And then the purple color is the New Haven County part of that. And then you've got Litchfield County in the pink color, and you've got Hartford County in the blue colored section. So that is the Naugatuck Valley planning region. And then you've got the South Central Connecticut planning region, which is mostly New Haven County, but obviously not a substantial part of New Haven County has now been severed and is part of the Naugatuck Valley planning region. Again, the good thing is these slides will be available to you, so you'll be able to take a look and use them for depicting a picture of your assessment areas and where they are relative to these planning regions. So the capital planning region is now on your screen. And you can see it's mostly Hartford County, but part of Hartford County's tracts to the west have been truncated, as we showed in the previous slide, and are part of the Naugatuck Valley planning region. And it includes most of Talon County, but there's a tract or two on the east side of Talon County, which is that yellow colored area, which are going to be part of the northeastern planning region as well. Nothing was done simply. Everything was complicated and overlapping. And unfortunately, you cannot ignore it because of CRA. The Community Reinvestment Act is now going to substitute what have been counties for hundreds of years for regional planning regions in Connecticut. They are what's called county equivalents. Now, I'm going to explain the ramifications for CRA purposes in a few more minutes. So there you go. This is the eastern side of Connecticut. You can see the northeastern planning region, which is mostly Windham County, but you could see part of Talon County is that yellow colored area up in the just the northwestern section of the northeastern planning region. And then part of Windham County is now part of the southeastern Connecticut planning region. You can see Windham County infringes on that little area that is the upper northern part of the southeast planning region. And you see that part of New London County is in the northeastern planning region. So when you look at the northeastern planning region, you're looking at part of Talon County is next as part of it, part of New London County is part of it, and Windham County, which is for the most part northeastern Connecticut planning region. A couple of those tracts are now in the southeastern Connecticut planning region. Certainly your heads are spinning right now thinking, oh, what a mess. And it is definitely makes it much more complicated, and Connecticut is unique. This is not something being done in the entire country. This is something that's unique to Connecticut. So you Connecticut banks have got to be aware of this and the implications for Connecticut banks. And now you've got the lower Connecticut Valley planning region. It's Middlesex and part of New London County. You can see the Middlesex part is the pink part, but the orange area still remains part of New London County, but that's going to be called the lower Connecticut Valley planning region itself. So again, we're combining two counties or parts of two counties into one planning region. Now, this is very important for you to understand. These are the MSAs. Connecticut basically now has 5 MSAs. Before it had 4 MSAs. And in addition, there's 2 non-MSA areas, basically. So this is really important for CRA purposes because under the current rule, as well as under the new rule, you have to be aware of where assessment areas are. And you're under the current rule, every bank is allowed to overlap an MSA, but it can't allow any of its assessment areas to, quote, substantially overlap an MSA boundary. So no matter what your size, there's some flexibility that remains in effect until January of 2026. But once January of 2026 hits, if you're a large bank, which at that point in time will be defined as a bank with $2 billion of asset size or larger, you would no longer be allowed to encroach on or extend over an MSA boundary. So banks that are in southwestern Connecticut, you'll be able to go anywhere within the Bridgeport-Stamford MSA, which includes 2 planning regions. It's got the Western Connecticut planning region. It's got the Greater Bridgeport planning region. That's that kind of group of brown colored tracts. They're in the lower southwestern part of the state. Then you're going to have the Waterbury-Shelton, Connecticut MSA, which this is really crazy because it takes part of Fairfield County, it takes a good chunk of New Haven County, and it takes part of Litchfield County, and it takes a few tracts that are part of Hartford County. And every single one of those tracts, which is in different counties, have been in different MSAs up until now. So now they're going to be all part of this one MSA called the Waterbury-Shelton, Connecticut MSA. And then you've got New Haven County, which is the New Haven MSA, or part of the New Haven County MSA, I should say, the purple colored area. And then you have the Hartford, West Hartford, East Hartford, Connecticut MSA, which is the mustard color tracts, which are the central part of Connecticut and embraces most of Hartford County, not all of Hartford County. It takes most Middlesex County, which again, the mustard color there, and a part of New London County. And then, of course, you've got the Norwich, New London MSA, which is denoted to the southeast. And then you have the two non-MSA areas in Connecticut. These are important for you to be aware of because you cannot, today you still have the flexibility so you can minimally overlap those boundaries, but you can't substantially overlap. And when you become a large bank in 2 years, you will forfeit any flexibility whatsoever. You will have to redraw. If you have any assessment areas that extend over these boundaries, you're going to have to reconfigure your assessment areas so that they're consistent with these boundaries. Now, this map shows you the where you can basically, there's two MSAs in Connecticut that contain two planning regions. And I want to make sure you're aware of that. So this is one chance where you could take what would be two planning regions and you can make each area one MSA, as long as you stay within that MSA. So you got the Western Connecticut and Greater Bridgeport planning regions can be part of the Western, is part of that Bridgeport MSA. And then you've got the Hartford and the Lower Connecticut Valley, the capital and region, and the Lower Connecticut River Valley planning regions. They're part of another MSA. Those are your two opportunities. If you want to minimize the number of your assessment areas, you can combine any assessment area that would be in the Greater Bridgeport area, planning region and the Western Connecticut planning region, or in the capital planning region and the Middlesex, the Lower Connecticut Valley planning region, and you can make that into one assessment area. The other areas in Connecticut, the other planning regions, are going to have to be isolated into their own CRA assessment areas. If you're a large bank, if you're a intermediate bank or a small bank, you will continue to have the flexibility to overlap those MSA boundaries, but you cannot substantially overlap that. Now, substantially is not defined in the regulation, but I would say if you start annexing an area on the other side of an MSA boundary that contains an entire town or city, you're definitely substantially overlapping and you would be violating the regulation. But on the other hand, if you just take 2 or 3 tracks that are contiguous with, but just on the other side of your assessment area boundary, but they're in one of the other planning regions, you're probably okay. But only if you're a intermediate bank or a small bank would you be allowed that flexibility. So this is very, very important for you to understand. So I'm putting them side by side here. You can see again, to the left, those are the MSAs. And to the right, you're looking at the planning regions. So you can see again how, let me just see if I can get a little fancy here. And bear with me a second. Try to do something. I'll probably regret, but I'm going to do it anyways. So, okay, I'm going to take my little tool here and see if I can. So as I did here, you've got, which is essentially this region here, or that MSA, and then you've got this region up here, planning region, and this one here. They're part of another MSA, which is the mustard color area here. And if you have assessment areas that are in any of these other areas, they're going to have to be isolated and broken down potentially. So banks, for example, that have a current assessment area that is New Haven County itself, well, you're going to have to break that up into 2 different assessment areas because New Haven County, which does include, for example, Waterbury is now part of another MSA, and you can't, and it's part of another planning region. So you cannot join Waterbury into New Haven anymore as a single assessment area. You're going to have to basically change it and make those separate areas. And again, by having these side by side juxtaposing things, you can see the MSAs on the left and you see the planning regions on the right. So that'll help you kind of grasp where you're going to have to look at your assessment areas and determine, do we need to redefine our assessment areas in light of the new rule when it, uh, even today, by the way, to some extent, because remember, everybody can overlap an MSA boundary today, no matter what your size, but you can't substantially overlap. So even if you're a small bank or an intermediate bank, you've got to be aware of this and know that where these new MSAs are, which are effective today. They're not effective in 2 years. These are MSAs which became effective coinciding with the effective date of the new regional planning regions, January 1st of 2024. These are now in effect. So if you have any problems caused by this, regardless of the fact that the new facility-based assessment areas have been postponed until January of 2026, you still might need to realign your assessment area maps to reflect this new reality, these new MSAs and the new planning regions. And it all depends on exactly how far your current assessment areas might overlap these new MSA boundaries. Let's see. Okay, whoops, I want there. Moving here. So let's kind of go back and talk about the implications of the new planning regions. So there's 9 new planning regions, which you've been looking at maps of, which are substituting for 8 counties. There's a unique 11-character tract number for every single census tract in Connecticut, which has now been changed. People think, oh, tell me a census tract number. Well, a census tract number consists of 11 characters. The first 2 characters are always the state. So the state in Connecticut is 09. The second set of characters, which are numbers 3, 4, and 5, are the county numbers or the county equivalent numbers. And the last 6 characters are what they call the tract number or the tract name. Now, tract numbers are unique only within a county or a county equivalent. So the problem is if you don't have the 11-character number, you can have tract number 1, 2, 3, 4, 5, 6, let's say in New Haven County, and you could have tract number 1, 2, 3, 4, 5, 6 in Fairfield County. So it's not unique unless you concatenate or contain all 11 characters for every tract. So what's happened now, since the planning regions have come into effect, the Census Bureau itself has changed every single complete tract number in Connecticut so that the 3rd, 4th, and 5th characters of the 11-character tract unique number are now changed. So every single tract is changed in Connecticut, and that's another reason why the FFIC is going along with these planning regions, because they won't be able to match up the tract numbers to the county numbers. They're only going to be able to match them up to the county equivalent, which are the planning regions. Now, the good thing is, of course, there's 1 or 2 decent things here. The census tract boundaries are not affected. A census tract boundary remains what it is. It's just that a census tract that was in Litchfield County might be part of the Western Connecticut planning region now, or a census tract that was in New Haven County in Waterbury is now no longer part of New Haven County, but it's entirely in the Naugatuck Valley planning region. So the boundaries are unaffected, but the county equivalent to which a tract is associated have been changed. You have to be aware of that. This means that the census tract income classes have been affected as well. Now, out of the 887 census tracts that are now in effect in Connecticut, 51 of the tracts had their income classification changed. Some of them went from low and mod to middle and upper, and some went from middle and upper to low and mod, because that's all computed based on the MSA in which you're located. And since we had 4 MSAs and now have 5 MSAs, that means every single MSA in Connecticut was reconfigured. And that means all the tracked income classifications had to be recomputed. The median family income for the county or county equivalent is the denominator in the calculation, and then the census tract median family income is the numerator. And since the counties have been changed now to county equivalents, that meant that the FFIC and the Census Bureau had to recalculate what the median family income is. For now, it's no longer Fairfield County. It's two planning regions that are in Fairfield County. So depending which part of that which planning region you're in, Fairfield County, which had a very, very high median family income, so it was like $120,000 or something like that. I am certain, I haven't looked at it. Actually, this would be interesting to look at the greater Bridgeport planning area, because I am certain that the median family income in that area was probably lowered quite a bit because it had been part of Fairfield County's median family income before, which means Greenwich and all the wealthy areas in the very southwestern part of Connecticut were part of the median family income of the tracts that were being computed in Bridgeport. But now all those wealthy parts of the lower Fairfield County are been eliminated. So that was going to have a big impact on the greater Bridgeport area, for example. The new MSAs do have significant CRA implications. And by the way, fair lending as well, because some of you, maybe I hope all of you know that there's been a very aggressive enforcement of the anti-redlining initiative taken on by the DOJ. And what the regulators have announced is that they're using either MSAs in their entirety or metropolitan divisions in their entirety. And the FDIC has said that they'll use counties or county equivalents in their entirety, but they won't break it down into anything smaller than that. So what does this mean? This means that the new regional planning regions and the new MSAs in Connecticut are going to have fair lending implications too, because the REMAs, the regionally expected market areas that are used for redlining analysis, are going to be changed because the regulators are using either county equivalents or the MSAs as the in their entirety as part of the REMA. So the new MSAs and the new planning regions have not only very profound impact on the Community Reinvestment Act considerations, they also have a very profound impact for fair lending as well. And now, combined with the new CRA rule, the facility-based assessment implementation will have a dramatic effect on Connecticut CRA assessment area delineation, because you can see again, especially it's already having an effect right now when banks still retain their flexibility. But when the new facility-based assessment area rules come into effect in January of 2026, and now banks that are $2 billion or more will not be able to encroach over an MSA boundary at all, it's going to have a very big implication if you're a $2 billion bank or above. So the large banks are not going to have the flexibility to adjust their assessment areas to the area that a bank can reasonably be expected to serve. They must index entire counties or county equivalents, and if it's not realistic to serve an entire county or the regional planning area, it doesn't matter if it's realistic or not. I know of some clients that we have that here in Connecticut that are going to be very adversely affected by that. They're going to have to take parts, for example, of the Western Connecticut planning region, which includes Lower Fairfield County, even though they don't have branches there, because they have branches, let's say up in Danbury or that area, and they don't have anything in southwestern Connecticut. Well, because that's all part of the same planning region, that means you're going to have to incorporate that into one assessment area. And for banks that don't have a branch system to serve the entire planning region, that's going to be a real handicap and a real detriment. It's one of the objections I raised to the new CRA. And mark this down. One of the most radical provisions in the new CRA is this removal of the flexibility that banks have had for 30 years now to delineate an assessment area that they can reasonably be expected to serve. That's no longer going to be in play if you're a large bank, which is only $2 billion or more in assets or above. And that's going to put you at a tremendous handicap. And the regulators responded to my objections by saying, well, the examiner in charge, the EIC, will take that into consideration as a performance context. But my response is, well, the whole point of the new CRA was to remove this subjectivity and to make it more objective, more quantifiable. And now, because of this arbitrary and capricious definition of assessment area and the elimination of the flexibility that has been inherent in the regulation for 30 years, you're going to have assessment areas that are impractical for a bank. And an impractical assessment area, an unrealistic assessment area, means unreliable statistical calculations. And you're going to be dependent on the good judgment of the EIC to say, oh, that's a performance context factor, which means that your results under the lending test, the retail lending test, when they become effective in 2 more years, your results are going to be discounted. But you're going to be put in the position right away of being in a defensive position, because right off the bat, you're going to look at your numbers. They're going to calculate all these calculations, all these formulas, and they're going to come up with a number. And it turns out that that number, in many cases, may not be realistic because it's predicated on a market that's an unrealistic assessment area. So unrealistic markets, unrealistic assessment areas means unrealistic performance expectations, which means unreliable and misleading performance conclusions. So I'm hoping that maybe somebody will gather their senses and make another amendment to the regulation. So there's 5 new MSAs replacing the 4 MSAs with very different boundaries, which I showed you a few minutes ago. The new MSAs not only affect tracked income class, like I explained, they do put limits on assessment area delineations. Remember that large banks for 2024 can be, so that no longer applies. That was a dilemma a number of you were in, that you were going to be called a large bank right now, and you're going to lose your flexibility. Thank goodness they waived that. We have 2 more years before that becomes effective, and we'll see what happens. So I put this little chart here together because there's all sorts of confusion of what they call the transition period, and when did the different sections of the regulation become effective. It would have been nice if they all became effective on the same date, but they didn't. So they had what's called the transition schedule, and you can see at the top there, April 1st, 2024 was the public file, the public notice, the publication of the exam schedule, what they call the public engagement provisions, and the facility-based assessment areas. Those all have been postponed to January of 2026, which is the next set of dates and sections of the regulation you can see in this chart. And you can see that 95% of the new rule was intended to become effective on January 1st of 2026. The only thing that's not effective on January 1st, 2026, I shouldn't say effective, applicable. Let me correct myself. The new regulation, the new rule, is effective on April 1st next week, April 1st, 2024. But the applicability dates, which means when a particular section becomes applied or applicable, are these different dates. And now that the April 1st, 2024 applicable dates, every single one of them has been, basically pushed back to January of 2026. So the list there for January 1st of 2026 is going to be expanded to add those other items in there. And then in January of 2027, there's only a couple of things that become effective. One of them, of course, is going to be the new test when they're going to be applied and the disclosure requirements of the new test. So that's going to be significant, but this is a handy chart for you to look at to make certain that you know exactly what becomes effective when. Now, the public file contents requirements, man, if they cause a lot of confusion with people, I've gotten countless phone calls like, I've heard that I've got to keep my maps in my public file for 5 years and this and that. And like most of the new rule, they didn't make anything simple. So the public file contents requirements have different retention periods depending on what the document is in the public file. So there's essentially 12 items that are going to be supposed to be retained in the public file. And when this becomes effective in January 1st of 2026, that's when where you're supposed to put your public file completely on the internet. If you have a public website for your bank, then your public file is supposed to be maintained on your website. And it's no choice at that point in time. Right now, there's a choice. You have a public website and you want to put your public file on the public website, you can do that. But come January 1st of 2026, you will not have that discretion anymore. And I don't know of a single Connecticut bank that doesn't have a public website. So, but these are the items. So let me quickly go through them. So the public comments for the current calendar quarter and post, by the way, updated every quarter of the current year. So it's not just April 1st. It'll be on, let's see, that'll be July 1st and October 1st and January 1st, basically. So it's supposed to be for the current year and the 2 prior calendar years. So number one, that's not a 3-year holding period. So you can see that, right? The latest CRA performance evaluation. Now, they don't specify in there how long. So by default, it means 3 years. The list of branches, including street address and census tract, again, they don't, the census tracts, by the way, that the branches are located in, again, that's for 3 years. The list of branches open and closed during the current calendar year and each of the 2 prior years. So there's an exception. So don't ask me why. You would think they would keep this for 3 years as well. But nope, and the regulation says each of the 2 prior calendar years. The list of the retail banking services, assessment area maps. So when the new, that's for your current CRA assessment areas, but it will become for the facility-based assessment areas and your retail lending assessment areas. So a retail lending assessment area is an area, an MSA, nothing smaller than an MSA, in which you've done at least 150 closed-end mortgage originations or 400 small business loan originations. So basically, it's and purchases, by the way. So you've got whenever you have a retail lending assessment area, it's going to depend on how much volume you do. And again, it's not restricted to a county; it's in the MSA level. So if you are going to have a retail lending assessment area because you've engaged in substantial lending in an area, an MSA where you don't have a facility, so it's not going to be a facility-based assessment area, then in those circumstances, if you cross that 150 closed-end mortgage threshold or 400 small business loans, then that's going to become your retail lending assessment area, and you're going to have a map in your public file reflecting that. You are given the discretion to add other information that as you choose. Banks who do report under Section 42 under the new CRA rule will have to post a written notice of the CRA disclosure statement for the bank and, by the way, for any affiliates on the FFIEC website. That's another thing I've not seen too much discussion of and controversy about with the new rule, but it will be mandatory for what they call operating subsidiary affiliates for the bank to not only collect its own data, but to collect and report the activity of the affiliates. And that's a very big contrast to how affiliates are handled today. Today, if you have an affiliate that is engaged in small business lending and that kind of a thing, and you don't have to have their activity incorporated in your CRA performance evaluation, but it's going to be mandatory under the new CRA. So that's a very big change, and I've heard very little comment about that publicly. So those of you that do have affiliates that are considered to be operating subsidiaries, you're going to have to collect their data, you're going to have to report their data, and your CRA performance is going to be affected by their activity as much as your own activity. You also have to, if you're a HMDA reporter, you're going to have to make public on the website that the HMDA disclosure documents are available on the agency website. If you're operating under a strategic plan, and I don't know if a single Connecticut bank that is, the strategic plan itself must be posted on your public website as long as you're operating under the plan. So that's indefinite. Small banks have to post their loan to deposit ratios for the previous year. Now, that means they're going to have to do it for all 3 years, of course. They're posting it the following year. And banks with a less than satisfactory performance evaluation, you have to describe your current efforts to improve performance and meet community needs updated for each calendar quarter. And that goes on until you basically attain a satisfactory performance evaluation. So let's talk about the public file, the location, and again, retention requirements. So the location of the public file, again, you've got banks that maintain a website. You have to maintain everything there. For banks that don't maintain a website, this is when this becomes effective. in 2 years, less than 2 years now, January 1st of 2026. So you can see all the information required for the bank's public file must be maintained at the main office, and if you're an interstate bank, at least one branch in each state. And at each branch, the following must be maintained. I'm not going to read all that stuff, but you can see that there's certain documents that have to be maintained at each branch as well. And then you have to provide documents upon request, either on paper or digital form, to the person making the request. And again, this is the provision, the timing requirements that have really what I'll call the data retention requirements, which have really gotten people confused. So, except as otherwise provided in this section, a bank must ensure that its public file contains the information required by the section for each of the previous 3 calendar quarters, with the most recent calendar year included in its file annually by April 1st of the current calendar year. So let's talk about the changes which become effective and effect on January 1st, 2026. So the requirement to post on your website, all sections must be maintained for 3 years, except as specified, which we just talked about. What are they again? I'll just reiterate. The public comments and branch openings and closures for the previous 2 years and the current year, up to date quarterly. All branch openings and closures for the current year and for previous 2 calendar years. The banks receiving less than a satisfactory performance rating must continue to post and keep things indefinitely on their public website until they attain a satisfactory rating. And banks with strategic plans must maintain a copy of the strategic plan on its public website. And the public notice provisions, basically, they remained pretty much the same as they are today. Again, they've been postponed to January of 2026. We have about 10 to 15 minutes left. I'm going to throw it open to questions.
Yeah, Len, there was a question in the chat. This is pertaining to the 2024 income classifications. It's just saying, did you say the 2024 income is currently published by the FFIEC website?
Yes, it's yes, it was posted, and
I know
we
that
can,
if
yeah,
I know that if you go to the FFIEC geocoding website, you can also now search and address by
right.
the 2024 income classifications. But they did also release
Hmm.
a file that has
Hmm.
the 2024 income classification, so you could do it either way.
Yeah, if you want an Excel spreadsheet with that, you can ask Geodata Vision, and we'll provide you an Excel spreadsheet with all 800 and whatever 70 some odd tracks in Connecticut and what they're tracking. Their 2024 tracked income classification is, and we can also show you those that changed because we have that available. So if you want, just let us know that you'd like to get a copy of that, and we'll be happy to provide it to you. We have about a dozen people or so, more than that, listening. Is there? That's the only question we got posted in the Q&A thing. There's 19 people here, so don't feel shy to just use you're not muted, so you can speak up. Does anyone have any questions? Or if you don't have questions, do you have anything that you want to discuss regarding the new planning regions, their implications for CRA and CRA assessment areas, the new MSAs, etc.? Does anyone have anything you either want to question or comment on? Got a very shy audience today, it looks like. Okay, well, if no one does,
Yeah,
I'll
Len,
give you.
what we'll do is let's plan on we'll just send an email out to everybody that was on the call today, Len, and we'll include
Mhm.
that list that you mentioned about the 2024 income classifications and the changes in Connecticut. We'll just provide that to everybody here. We'll get
Mhm.
that done in the next couple days once we release the recording.
Mhm.
So we'll make sure that becomes available.
Okay. Well, good. It's great that we got a 2-year postponement. It gives you a little more time to catch your breath as far as the new CRA is concerned. But unfortunately, the Connecticut legislators, in their wisdom, did impose these new planning regions, and they have big implications, as I've said over and over again. And so you have to be aware of that. And they definitely have implications for your CRA assessment area delineation. So make certain that your public file is going to be up to date next week, and especially with regarding the assessment areas, and be aware that the new planning regions, if they have an effect on your assessment areas, and probably they do for every one of you today, that you get a new public file map that reflects the new planning regions as they affect or pertain to your CRA assessment areas. And certainly give us a call or contact us if you have any questions. And we've been backed up the wazoo with maps. Let's see, one more Q&A came in here. Yes, well, yes, you can. The 2024 tract income classifications have been published, and they're in
And
the
Len, I
form.
think that's the
Yeah.
same question, Len.
Oh,
That was
okay.
already answered. Sorry, I meant to
Okay.
hit answered. So,
Oh, okay. So yeah, so when they say income, we're talking about the tract income
uh-huh.
classifications, all right?
Yeah.
And they will publish, as they do in the middle of the year, the updated 2024 demographic file. And so you'll also see the answers there. That typically gets published in June. But we've got it already, and since you're our clients, we'll make it available to you upon request, no questions asked. All right, well then, thank you very much for participating today.
Len,
And
I might
yeah,
just suggest if you want, maybe stop the recording.
okay, hold on a second. I'm gonna stop. I just realized I clicked, I'm recording.